the TAC's role in common law compensation? Henry Carus of Henry Carus and Associates is here today, and he is going to answer that question and more. So Henry, thanks for being here today.
My pleasure, Cindy.
Well, Henry, what is common law compensation?
Wow, okay. Now, lots of my clients come in and ask that question, or I even just give it to them just to help them out. Common law compensation is a concept that we have in most Western societies that have hailed their heritage from England, and that means that simply that if I do something wrong to you, I'm obligated to provide you with some compensation to change what I've done. And in the personal injury world, common law compensation means giving you compensation in money to try to help you with your life because you've been injured as a result of my negligence, my mistake.
All right, and when can I get common law compensation?
If we're talking about in Victoria and we're talking about the TAC, common law compensation exists. It's available to people in any road accident as long as they've been injured by a motor vehicle. But the TAC legislation that we work with restricts access to common law only to those people who are seriously injured.
And how do I get common law compensation?
Well, I just tweaked that little expression, serious injury, to you, and that's where the start of the process is. You must ask the TAC for access to common law. They are essentially the gatekeeper to common law compensation. As a government agency, their role is to ensure that that kind of compensation is only available to those seriously injured. So the process that we have is we must ask TAC at first instance, can we have access to common law? Can you give us a serious injury certificate assuring us that we are seriously injured or accepting that we're seriously injured? And the TAC has two roles to play in that. They can say yes or they can say no. And if they say no, then there are ways of contesting it. If they say yes, access is provided.
What if TAC does not wish to give me a serious injury certificate?
If you don't get the serious injury certificate, then the process allows you to not, and there's no requirement as to when you do it, you can actually reflect on it, allows you to take the contest or the question to the county court, which is our local court of many jurisdictions in terms of general jurisdiction. And the county court judges are familiar with the question of whether someone is seriously injured. And there's a whole process in that courthouse for hearing an application for a serious injury. It's mostly done on the papers in terms of paperwork that's created, and the only witness that's usually required is the plaintiff himself to indicate or to testify as to what has happened in that person's life.
And what would you say are the chances of success in court?
At the moment, we got close to 30 years of time with this legislation, so we have really started to have an understanding of what we think whether someone is seriously injured or not. So the chances of getting a certificate on request, pretty good, because we're selecting or pre-selecting which ones we think have a good chance. The ones that we get knocked back by TAC and they say, no, we're not going to give you a certificate, and we decide to bring it to the courthouse, we're winning at the moment probably 90% of those claims, because again, the firms in town are intelligent about which ones they decide are going to be contested or not.
Okay, and what happens once I get the serious injury certificate?
The certificate gives you the right to commence common law proceedings. And it could be against the driver of a vehicle, or it could be against the road authority for the condition of a road. It just gives you that right. If you have that certificate and the TAC is in a position where they can discuss with you a resolution of the claim because they are the insurer for the vehicle involved, then that's likely what's going to happen. They're going to invite you in for a conference to see whether or not they can resolve the matter. If they're not in that position, then you may be chasing another claim or another compensation type of proceeding against someone else who may be responsible for your accident.
Henry, how much common law compensation can I expect?
The values change quite dramatically. The maximum at the moment, I think, is about $1.3 million for the total level of compensation that's available to someone. The areas of compensation are limited. They're limited to two areas, and that is for pain and suffering, or the change in someone's life, and for economic loss, being wages lost in the past and wages likely to be lost into the future. And those are the two areas that comprise the 1.3 million that I just mentioned. How much of that you get depends on your personal circumstances, how your injuries rate in terms of other people who have been compensated, and to what extent is it going to be accepted that you have not been able to work or will not be able to work in the future because of your injuries.
And do I need a lawyer in order to get common law compensation?
I would say that's 100% agreed. across the board. In fact, the TAC legislation doesn't require it, but in the materials that the TAC send to you, and they mention common law in their materials, they'll say to you, you should speak to a lawyer to advise you about your common law rights. There's no way the average person can truly understand what is common law compensation, what can I ask for. They don't have the experience to even compare themselves to other injured people, and they never will understand what it means to bring a legal proceeding against someone seeking that compensation. So if you are in that position, you should have a lawyer. But in my opinion, as I may have mentioned to you in the past, Cindy, if you have any transport accident, any TAC claim, you should be having a lawyer from the beginning.
Great information, Henry. Thank you for being with us today.
My pleasure, Cindy. Be well.
Until next time, this is Cindy Speaker for Victoria Law TV.